Cool, definitely came. All right, well, let's go ahead and get going here. All right, hello, Southern Ionics. My name is Daisy. Welcome to today's minor and elderly care session. The session will be presented by attorney Amanda Reed. Before I kick it over to Amanda, I'm just going to go ahead and remind folks of all of the features that they have access to. So everyone has access to Rocket Lawyer. You simply have to go to the claim link down at the bottom, go.rocketlawyer.com/Southern Ionics. And some of the features that you all have access to are the legal documents library. You can create over 1,000 different state-specific documents, quick on-demand Q&A with attorneys, free 30-minute consultations with attorneys. Should you want to retain an attorney, you are entitled to up to a 40% discounted rate. You also get half off on Rocket Tax. Again, the claim link is go.rocketlawyer.com/Southern Ionics. And just to give you a little bit of info on some of the things that you can find assistance with in Rocket Lawyer, you can definitely find documents on estate planning. You might be getting married, buying a home, starting a family, that you might need to take care of, little ones or older folks that you might need to take care of and support, such as grandparents or parents, landlord-tenant issues, immigration questions or issues. Again, not an exhaustive list, but just wanted to throw some very common things that people find assistance with in the Rocket Lawyer benefit. Again, the claim link is go.rocketlawyer.com/Southern Ionics. You can also ask Keely for the claim link as well. All right, so without further ado, I'm going to go ahead and kick it over to Amanda for the remainder of the presentation.
Thanks, Daisy. Hey guys, my name's Amanda. I'm an attorney in North Carolina. I practice primarily in estates, so I am drafting estate plans, wills, trusts, powers of attorney. We do guardianship proceedings, as well as incompetency proceedings, special needs planning. We do probate, estate administration, and trust administration as well. So the topics that we're going to cover in today's presentation are things that I talk about with my clients constantly. So they are topics that I deal with on a regular basis, and certainly something I have a little bit of knowledge, personal knowledge about. So this presentation is just legal information, not specific legal advice. I am only licensed in North Carolina, so I can only give state-specific legal advice. If you are a resident of North Carolina as well, I do typically save 5 to 10 minutes at the end of the presentation for questions. So if we're going through the presentation and something comes to mind, I just ask that you put it in the chat. I will get to those questions at the end. Or if you prefer, you can wait until the end and take yourself off mute and ask me your questions directly. So we are going to jump off today with some minor care topics. I think it's helpful to define who a minor is. A minor is a person who is under a certain age, and that age legally demarcates childhood from adulthood. So this is an age that is controlled entirely by your state statutory law. So that means that every state could, in theory, choose a different age of majority. Commonly, that age is 18. But that can vary by jurisdiction, of course. If you're a resident of Puerto Rico, actually the age of majority there is 21, for example. Minors are considered to be under the care of a parent or natural guardian at all points until they reach the age of majority, unless they are emancipated. So to be emancipated means that a minor has filed a petition with the court and has asked the court to allow them to make their own medical, financial, or contractual decisions, despite the fact they're under the age of majority. We see a lot of minor celebrities and like minor recording artists being emancipated from their parents, not necessarily because they don't have a good relationship with their parents, or they don't want their parents involved in their lives. More times than not, it is because those minor celebrities or recording artists want to be able to enter into contracts without having to have their parents negotiate those contracts on their behalf. So unless you are legally emancipated, a minor child is going to be under the care of a parent or natural guardian until they reach the age of majority. Not all minors are considered juveniles in terms of criminal responsibilities. We are not going to talk about criminal law too much today. It is not an area of law that I practice in or really have that much knowledge in. But for what it's worth, there are often times where a minor may be charged as an adult in a criminal proceeding. That is going to be determined by the types of crimes that are being committed, whether it is a misdemeanor or a felony, as well as the minor's criminal history, right? So if they're a habitual offender, they may have a higher likelihood of being charged as an adult for their criminal offenses. We do see minors being charged as adults. You will never see an adult charged as a minor. It is not a two-way street. It does not work like that. So then who is considered a natural guardian? So a natural guardian is someone who can make decisions on behalf of a minor, so someone under the legal age of majority. This individual is going to be able to determine things like where they are enrolled in school, what types of medical treatments they receive. The natural guardian is going to be responsible for making most of the legal decisions on behalf of the child, contractual decisions on behalf of that minor, and their medical decisions. A natural guardian is going to be a birth parent, so someone identified on the birth certificate, a legal adoptive parent, so someone who has gone through the court process to legally adopt the minor child. We are often seeing the birth certificate updated when we have a legal adoption. And then also a court-appointed guardian. So this is someone that's appointed by the court to make these types of decisions on behalf of a minor child. A natural guardian is not a grandparent, a step-parent, an adult sibling, or other adult family member. And I think that is a little counterintuitive. But grandparents, step-parents, other adult family members, they don't have any natural authority to make these types of decisions on behalf of a minor. Now, realistically, it happens all the time, right? Someone kind of steps up to make these important decisions on behalf of those minor children. Unfortunately, they don't have any natural authority to do that. So those legal decisions that they may be making, those medical decisions they may be making, are not typically enforceable. A grandparent, step-parent, or other adult family member can become a natural guardian. So they have the legal authority to make those decisions, but they do have to go through the court process in order to be appointed in those roles. There's no natural ability for these types of individuals to serve in this role. When we have someone that has kind of filled those shoes of a parent, that's where we see someone acting in loco parentis. This is a term that means in place of a parent. This is a type of relationship that exists when someone voluntarily undertakes the care and control of a minor, when there is a distinct lack of a natural guardian, as well as an absence of formal legal approval. So this person has just kind of stepped in to fill this role of a parental figure and is trying to make these types of decisions. Unfortunately, although the majority of the time, someone that is serving in loco parentis, has their head and their heart in the right place, right? They're trying to do the right thing by the minor. Unfortunately, this often causes some issues. Someone that's acting in loco parentis does not have the legal authority to enroll a child in school. They don't have the legal authority to make major medical decisions. They don't have the legal authority to enroll the minor child in extracurricular activities, like to sign them up for Girl Scouts or for a recreational sport. It's oftentimes in those types of situations where someone who is acting in loco parentis kind of hits a roadblock, right? It's when one of those organizations pushes back and says, unfortunately, you don't have any legal authority to make this decision on behalf of the minor. And then oftentimes that forces us into like an emergency guardianship proceeding, okay? So then emergency guardianship proceedings are costly, even more so than a regular guardianship proceeding, and they still take time, right? So I urge you, if you or someone you know is acting in loco parentis for someone, a grandparent making decisions for a grandchild, an aunt making decisions for a niece or nephew, or an older sibling making decisions for a younger sibling, go through that court process, right? Get these documents in place, get that formal legal approval from the court that says you have the legal authority to make those types of decisions for that minor child. It's a great use of your Rocket Lawyer benefits, taking advantage of that 40% discount to find yourself an attorney who can guide you through that process. But it's one of those things that if you do it ahead of time, you are going to find that you can be much more efficient serving in that role. So if a minor child is going to be away from their parents or natural guardians for a period of time, I do also like for you guys to consider doing a health directive for that minor child. So this is the type of legal document that allows you to designate someone else to make medical decisions for your minor child for a limited period of time. So if your child is going to be staying with their grandparents for an extended period of time over the summer, they're studying abroad, they're going on a mission trip, or like a church youth group trip, going to be away from their primary guardian for a period of time, get this health directive, right? It's a document that's free through Rocket Lawyer. You can create this document, designate someone to make those medical decisions for your child. You are preventing someone from acting in loco parentis if they need to receive medical care. Our next slide is just some court-appointed guardians, the most common types of court-appointed guardians you will see. The first one is a guardian ad litem. So this is a court-appointed guardian who represents the best interest of the minor. So this is typically an attorney. We like to see attorneys appointed in these roles because we have a little bit better understanding of the statutory laws. But whenever there is a minor or an incapacitated adult that has an interest in a legal proceeding, so a wrongful death claim, personal injury claim, oftentimes we see them utilized in estate proceedings. There's a minor child with an interest or an incapacitated adult with an interest in the outcome of that legal proceeding. You are almost always going to see a guardian ad litem appointed, right? So this person steps into the shoes of the minor child and makes decisions that are in their best interest on their behalf, okay? Mom and dad cannot make decisions on behalf of a minor child as they relate to a legal proceeding. Natural guardians otherwise cannot make legal decisions on behalf of a minor child or incapacitated adult in a legal proceeding otherwise, right? So we're always going to see a guardian ad litem being appointed, even if mom or dad are available and able to make decisions for their children. They cannot in most legal proceedings. So for example, in an estate administration where we have a minor child who has inherited some real property, so a house from their grandmother. Now the house is to be sold. That minor child cannot enter into a sale of real property. A minor child cannot enter into a contract. So a guardian ad litem is appointed to represent the minor's interest in that transaction. So they are going to ensure that the property is listed for fair market value. They're going to ensure that at closing, all of the closing materials are correct. They're going to sign on behalf of the minor at that closing, and then they're going to ensure that any proceeds payable to the minor child are appropriately distributed after that closing ends. So again, just an individual that is appointed by the court to step into the shoes of the minor and make decisions that are in the best interest of the minor. Guardian of the estate is a court-appointed guardian that we see most often for either minors or incapacitated adults whenever there is money involved. So this individual is appointed by the court. There's an application process. They're required to be bonded. Once they are appointed in this role, they have to file an annual accounting to account for all of the money that they are managing and responsible for on behalf of the minor, the incapacitated adult. Again, in an estate proceeding, for example, where we have a minor child who's inheriting a lump sum of money, let's say $10,000. I cannot distribute that money to a minor child. Okay, I can't give that money to that minor child. I also can't give the money to that minor child's mother or father. That is a request I get all the time. Well, just give the money to me and I'll take care of it. Unfortunately, no, I can't do that. So because I can't give that money to a minor child, I'm kind of limited in what I can do with it. I can either deposit that money with the court, where the court will hold on to it until they reach the age of majority and then distribute it to the minor child or to the adult child at that point. Or you can have a guardian of the estate appointed. So this person would, after making application and being appointed in this role, they would then take possession of that money on behalf of the minor, and they are responsible for managing that money. We also see this with incapacitated adults, people who can't make their own financial decisions any longer due to incapacity. We can have a guardian of the estate appointed to manage and control their assets, make sure that their bills and things are getting paid on time. Guardian of the person is our third and final court-appointed guardian. This is an individual that is appointed to make medical decisions. So they are strictly limited to making medical decisions. Typically, we see guardian of the person more in situations where we have an incapacitated adult, less so with minors because, of course, they have their natural guardian parents who are able to make those decisions for them. So we see this a lot more with incapacitated adults. This person does have to make application to the court. There is typically no bonding requirement. There's typically no accounting requirements either with this one. You are just being authorized by the courts to make medical decisions on behalf of that individual. So our next slide is about the UTMA and the UGMA. And these are types of custodial accounts that allow us to put money in them to be held for a minor beneficiary. So in situations where, like my example, where we have a minor child receiving a distribution from an estate, I don't want to put the money with the court, but I also can't get anyone appointed as the guardian of that minor child's estate. The UTMA and the UGMA give us another option, right? So these are statutory codes that allow a minor to receive that inheritance without having to have a legal guardian appointed. So we're able to create these types of fiduciary accounts so that the money can be deposited. It is invested typically, but it is held there and protected until they reach a certain age. So some benefits with these accounts, our kids are seeing the value of investing and saving. There are lower tax consequences on any interest that is earned in these types of accounts. And then, of course, the money is not tied up with the courts, right? We don't have to deal with that idea of the inheritance is frozen. And we don't have to go through the process of getting someone appointed as the minor child's guardian of the estate, right? No accountings, no bondings, things like that. So there are definitely some benefits to these types of accounts. Some negatives, though, the money is legally owned by the minor. The accounts kind of do tie up the money, right? We can't make withdrawals. We can't use that money for anything until they reach that specific age. And those minor children owning that money does sometimes have a negative impact on their ability to receive financial aid. So if your children are at the age where they may be filling out the FAFSA, looking for some scholarships, getting ready for college, they do have to disclose that they are the legal owner of money held in UTMA and UGMA accounts. So speaking of college age children, it's a great idea and another great use of your Rocket Lawyer benefits to have your young adult children, so your 18, 19, 20, 21-year-old children, execute financial and healthcare powers of attorney before they leave for college. So these types of documents will allow someone else to make financial and medical decisions on behalf of those young adult children. When I was 18, I moved 500 miles away to go to college. My parents were still making deposits and withdrawals from my bank account, to pay my credit card bills or my car insurance. They were still calling to schedule my dentist appointment when I was home for spring break, right? Legally, they weren't allowed to do those things. Realistically, I'm a mom myself, so I would take care of my kids forever if I could. Legally, mom and dad can't do those things, right? So these types of legal documents allow those young adult children to give legal authority to mom or dad or some other trusted adult to help them in continuing to make those financial and healthcare decisions. So another great use of your Rocket Lawyer benefits there, having those documents drafted and executed by your young adult children. And one other thing that I want to touch on before I go on to the next slide, if you have minor children, so if you have one or more minor children, you really want to take advantage of the last will and testament that's available through the Rocket Lawyer platform. Pull that document up and make sure that you are including language that designates a legal guardian for your minor child. Okay, so if you die and your child is still under the age of 18, who is going to be legally responsible for that child if you cannot make those decisions any longer because you have died, right? The last will and testament is the only document that we can utilize to make that designation. So if you don't take advantage of it, you don't get that opportunity to control the individual that may be responsible for your children. So you want to make sure that you're using that last will and testament, make sure you're getting that guardianship provision in there. So you have the ability to make the recommendation to the court of who would serve in that role on your behalf. If you don't have a will, if you have a will and you don't have that guardianship language in there, no one has the legal authority to physically take custody of your child. Oftentimes that's where we see children ending up in foster care or group home for a period while they wait for someone to come forward and voluntarily petition the court to be appointed as their guardian of the estate and guardian of the person, okay? The alternative to that is you have a will, that designates someone. That person can automatically take physical possession of your child. They will still have to apply with the courts in order to make legal decisions for them. They will have to go through that guardianship process, but it's significantly less intrusive, significantly less expensive if you've already made that recommendation to the court ahead of time. We also want to be using those last will and testaments to include a testamentary trust. So this is a really great estate planning tool if you are doing some planning and you have minor children, minor grandchildren, minor beneficiaries, right? Someone that could receive a portion of your estate maybe under the age of majority. Testamentary trusts allow us to take an inheritance that a minor child would receive and hold it in trust for their benefit. Once they reach a specific age, that money is distributed outright in a lump sum. But until they reach that age, we have the ability to utilize that inheritance for things like educational expenses, for tuition, medical bills, if they need to buy a car, if they need to pay rent. We have the ability to go into that trust and use those funds for that minor child's benefit, okay? This is the best option out of all of the options that we've already talked about, right? We don't want the money to be held with the court. We don't want it to be frozen there. We don't want to put it in a UTMA or UGMA account because, again, it is frozen in those types of accounts. And then with the guardian of the estate, you know, there's application process, there's accounting process, there's bonding requirements on an annual basis. You can forego all of that if you have the testamentary trust language in your will. That will allow that inheritance to be used for your child without all those other steps being involved. So definitely a provision that you want to make sure is being included in your last will and testament if you are planning for some minor children. All right. The next portion of our presentation is going to be about some elderly care topics. We are going to discuss some state and federal programs that are always a hot topic when I am discussing estate planning with our clients. So the first program we're going to talk about is Medicare. This is the federal health insurance program. The only requirements for this program is that you are 65 years or older. This is an age-based program. People with certain disabilities, people with end-stage renal disease may qualify for Medicare, even if they are not 65. But for the vast majority of folks, you are going to wait until you are 65 and you are automatically going to be enrolled in the Medicare program. So Medicare is made up of a number of parts. Part A is your hospital insurance. This portion of the Medicare program is funded via a payroll tax. So if you pull out your pay stub, you'll see a line item on there that pays into Medicare. This is what you're paying for, Part A, hospital insurance. This is the portion of the program that is free to everyone as long as you are 65 years or older and have contributed to the program. This covers inpatient hospital stays. So if you are overnight, if you are in ICU, if you've been admitted to the hospital, your inpatient hospital stays will be covered under Medicare Part A. Also, a portion of the skilled nursing charges can also be covered under Medicare. I think it's something like 90-ish days of skilled nursing are covered under Part A hospital insurance. Part B is an elective coverage. This is the medical insurance that is offered under Medicare. This is going to cover your standard doctor's visits, so seeing your primary care physician, going to your annual physical. Outpatient procedures are typically covered under Part B, and then also any medical supplies. So if you have diabetes, you use a CPAP machine, those things will be covered under the Part B medical insurance. Because this is an optional program, if you elect to enroll in an insurance program through Part B Medicare, there is going to be a cost attributed to that. The cost for it will be based on the income that you report on your federal tax return. So the cost for everyone is going to vary a little bit, but most people elect to have the cost of Part B medical insurance deducted from their Social Security. So you just receive your Social Security check every month, and that amount is less the cost of the Part B medical insurance that you enrolled in. And then for your prescription coverage under Medicare is actually Part D, it's not Part C. And this is going to cover any prescriptions that you're picking up from the pharmacy. It's also going to cover shots and vaccines, whether those are mandatory or voluntary. So flu shots, COVID shots, shingles, vaccines, pneumonia shots. There are shots and vaccines for literally everything these days. So all of those things would be covered under the Part D prescription coverage. Medicaid is the next program we are going to talk about. This is the state health insurance program. This is a needs-based program. It is available to low-income adults, children of low-income adults, low-income seniors, low-income pregnant women, and individuals with certain disabilities, sometimes regardless of their income, depending on what type of disability they have. This is a state-specific program. So every state's Medicaid qualifications, restrictions, limitations, they're going to be different. So if you have specific questions about Medicaid, I really urge you to reach out to a Rocket Lawyer on-call attorney who is licensed in your state and ask that attorney your specific Medicaid questions. Because it is so state-specific, there are a lot of nuances that vary from place to place. It would be impossible for me to give anyone, any realistic advice about the Medicaid program other than to just kind of talk about it generally. So because this is a state-specific program, there is a lot of federal funding that comes into this program. So in order to maintain that federal funding, there are certain mandatory benefits that are required. So hospital services, both inpatient, outpatient hospital services, doctor's visits with your primary care physician, as well as your specialists, most of your medical procedures, at labs, x-rays, blood work, most operations, and home health services are covered under the Medicaid program. So nursing home, rehabilitation centers, in-home care, hospice care, that stuff is covered under Medicaid. Some states elect to include prescription coverages and therapy coverage under Medicaid, but again, that's going to vary from state to state. So this is, again, this is the needs-based program. In order to be qualified for the Medicaid program, you have to be below your state's income threshold and below your state's asset threshold. So when we're looking at income for Medicaid qualification purposes, we need to look at all of your income. So any money you're receiving from an employer, money you're receiving from a business that you own, income you're receiving from dividends on any investment policies, if you're required to take RMDs, required minimum distributions from your IRAs, we're going to include that in your income bracket. If you're receiving a pension, if you are receiving rental income, if you are receiving royalties from a book you wrote or a copyright you own, if you have mineral rights, any of that income you're receiving, as well as your Social Security, all of that income has to be disclosed. When we are looking at the asset portion of Medicaid qualification, you have to disclose the fair market value of all of the assets you own. So that's any real property you own, your primary residence, any commercial property or investment properties. You have to disclose the fair market value of all of your investment accounts, all of your retirement accounts, the fair market value of your life insurance policies. You have to disclose the fair market value of your car and your household items. You have to disclose the fair market value of any businesses that you own or mineral rights that you have. Literally anything that you own, we have to disclose those assets on that Medicaid qualification. And then in order to be qualified for Medicaid, you have to be below the income threshold and the asset threshold. This is an and, people, okay? It's not one or the other, it is both. You have to be under income and assets. Those thresholds are notoriously low. I mean, low, okay? In North Carolina, you can have about $1,600 worth of income per month and about $2,000 worth of assets. So it is difficult to qualify for the Medicaid program. If you have one retirement account, you are not going to qualify for Medicaid. Kind of as a rule of thumb, I tell people if you've never qualified for Medicaid before, it is unlikely that you will qualify for Medicaid in the future, okay? If being in a nursing home or having to have 24-hour in-home care is a reality of your family history or your medical condition, I would strongly urge you to look into long-term care insurance, because it is difficult to get qualified for the Medicaid program, and it is only going to continue to get harder. So bear in mind that the Medicaid program requires that you qualify under income and assets. And this is probably the #1 program that we talk about with our older clients. How do I protect my assets from Medicaid? How do I make sure that the nursing home doesn't come and take my house, or that the government won't come and take my house? This program does not work like that. That is like the #1 myth that I would love to dispel in my lifetime. Medicaid does not work like that. Okay. The nursing home doesn't want your house. The government doesn't want your house. What they want is for you to private pay for your care first. Okay. You're not going to get into a nursing home and then have Medicaid say, okay, we're taking your house to pay for the nursing home. You are expected to utilize the value of the assets you own to private pay for your care. And then once you have spent down all of those assets and you're below the income and the asset threshold, then you will qualify for Medicaid. Okay. So I feel like this program has been glamorized a little bit. That it's free care for everybody, and you just have to do all these things to kind of shift your assets around and shield your assets from Medicaid so you can get qualified. The harsh reality of it is the majority of people are not going to qualify for this program. So it is a great program. Its intention is to provide a way to pay for medical care that otherwise an individual would not be able to afford. It is not there so that someone who has 10 retirement accounts and $1 million in life insurance can go into a Medicaid nursing home for free, right? So state-based, specific state requirements on this one. If you have more questions about Medicaid, certainly reach out to an attorney licensed in your state. Social Security is next. This is a federal program that provides retirement benefits to our retired workforce and benefits to disabled workers. We also finance this program through a payroll tax. You are entitled to your Social Security benefits as early as 62. If you elect to take them at 62, you will take a decreased amount for the remainder of your life. If you wait until you are 67, you will receive the full benefits. As of January 2022, so a little over 2 years ago, the average benefit was $1,614 per person. That has gone up a little bit to about $1,800 per person. If you recall, when we were talking about Medicaid on the last slide, I said in North Carolina, you can only have $1,600 a month in income. So if you are receiving the average benefit of Social Security in North Carolina, you are not going to qualify for Medicaid. So they do take that Social Security into consideration during that Medicaid qualification process. Benefits transfer to our surviving spouses as well as to minors of deceased workers. So if you and your spouse are collecting Social Security, your spouse dies, you can amend your Social Security to take the higher of the two. You can't collect both, but you can take the higher of the two. And Social Security benefits are available to minors of deceased workers. So if you die and you have minor children, those minor children are going to share your Social Security benefits equally up until they reach 18. All right, and then this isn't really a federal or state program, but arguably I think it's just important. The idea of competency. So many of the topics we have talked about already kind of revolve around this idea of competency, right? Those minors are presumed to not be competent because they are below the age of majority. Oftentimes we find ourselves dealing with competency as we get older. The competency wanes a little bit. We have a higher risk of things like dementia and Alzheimer's. Competency means that you understand your actions and understand the consequences of your actions. And we really need individuals to be competent, not only to do their estate planning, but obviously in so many other facets of life as well that we've already talked about, right? You can be temporarily incapacitated. That is a situation where you are under anesthesia, or you are unconscious, or maybe in a medically induced coma. Dementia can also be a temporary incompetency. Being diagnosed with dementia does not mean that you are permanently incapacitated, okay? We see a lot of clients who have already been diagnosed with dementia. We recognize that with that disease comes periods of competency as well as periods of incompetency. So we try to direct the client to talk to us, to schedule their appointments during periods where they know they will be competent. Okay, if that's first thing in the morning, great. We will have a conversation with them first thing in the morning. Throughout the day, typically their competency can wane. But just because they have been diagnosed with dementia, just because they have a temporary incompetency does not mean that they are permanently incapacitated. Permanent incompetency is going to be those progressive end stages of dementia, Alzheimer's. Individuals with certain types of disabilities, they may have been deemed permanently incapacitated for the majority of their lives. Permanent incompetency means that you will never regain your competency, okay? In any case of incompetency, whether it's temporary or permanent, an incompetency and guardianship proceeding is going to be required in order for someone to make decisions on behalf of that incapacitated individual, unless you have estate planning documents already in place for those folks that will control instead of having to go through those guardianship proceedings. Guardianship proceedings are kind of a necessary evil in my world. There will always be individuals who are permanently incapacitated. We want to make sure that people who are permanently incapacitated from birth, that they get the proper legal representation, and we make sure that the person being appointed really has their best interest at heart in mind. So guardianship proceedings are always going to be necessary, but they can be avoided for the vast majority of individuals. We avoid those incompetency and guardianship proceedings by having a financial power of attorney, which is a legal document that allows someone to make financial and contractual decisions for you. This individual is going to be able to make all of those decisions on your behalf, right? They're going to be able to immediately make those decisions if you become incapacitated. So if you have dementia 20 or 30 years from now, the person you've designated in your financial power of attorney today is still going to be able to act on your behalf. Having this legal document that has been drafted and executed is going to allow that person to immediately step in and immediately start making those decisions for you without having to go through any of those court proceedings. Same thing with the healthcare power of attorney. This document allows you to designate someone to make medical decisions for you. So you are essentially designating the guardian of your person without having to go through those court processes, right? We're not having to have an incompetency proceeding. We're not having to have a guardianship proceeding. The individual designated in this document can take this document and immediately start making these types of medical decisions on your behalf. We also like to encourage our clients to get advanced directives. Sometimes these are called a living will, but it's the pull the plug document. You get to make decisions regarding end of life care. Do you want your life prolonged by a machine? If you are going to die, death is imminent, you're going to die within a few hours or a few days. Do you want your life to be prolonged by some type of machine, something pumping your heart, something breathing for you? You get to make those decisions in this advanced directive. And then, of course, the last will and testament. We want to utilize this document to make distributions of our estate, so of our assets, to the people that we want to receive them. There is a misconception that if you are married, everything automatically passes to your spouse when you die. So if you're married, you don't need a will. That is so far from the truth. In the majority of states, if you are married, your estate doesn't pass to your spouse. In fact, your spouse shares an interest in your estate with your children, who could be minors. And then we have to have guardian of the estate and guardian ad litem's appointed. If you don't have children, your spouse may share an interest in your estate with your surviving parents, so their in-laws. Believe it or not, I have seen those scenarios play out in real life, and they're terrible. They never work out. So if you intend for your spouse to receive everything, I strongly, strongly, strongly encourage you to have a will that says everything to my spouse. You also get to use your will to name an executor. This is the person who is responsible for all of the administrative stuff that comes with handling an estate, filing the will for probate, collecting your assets, making distributions to your beneficiaries. You get to choose who this person is. In the alternative, if you don't have a will, the court is going to choose someone to do this stuff for you. So it's just another opportunity for you to kind of be in control. And then we've already talked about how important it is to have the last will and testament if we're planning for minor children, making sure that you are taking that opportunity to designate the legal guardian for them, who will make their medical decisions, who will make their legal and contractual decisions if you are not able to make those decisions for them, because you have died and they're still a minor. So again, just another opportunity for you to be in the driver's seat. You get to choose who this person is. If you don't have that language in there, it is likely that the court will make that decision for you. And that wraps up my portion of the presentation. So all of the documents that we talked about at the end of the presentation, they're all available to you via the Rocket Lawyer platform. I strongly encourage you guys to take advantage of them. You know, making sure that you're being proactive in your planning, whether that is planning for a, you know, minor child or minor beneficiary, or helping to guide, you know, an elderly parent through this process. Definitely take advantage of those documents that Rocket Lawyer provides.
Thank you so much for the presentation, Amanda. I hope that everyone finds it helpful and insightful. Again, just to echo Amanda, you can find all of the documents on Rocket Lawyer and more. You can also ask questions to attorneys, free 30-minute consultations if you need them. You're also entitled up to 40% off attorney hourly rates. Should you want to retain an attorney, you're also entitled to half off on Rocket Tax. Your claim link is go.rocketlawyer.com/Southern Ionics. Thank you so much, Amanda, and thank you, Southern Ionics. I hope everyone has a wonderful day. Bye-bye.